Ready, start. The above batch of appeals arise from the judgment of the learned single judge of the High Court of Judicature at Bombay, Nagpur bench, full stop. The impugned judgment refused to interfere with the order of the Industrial Code, which allowed the complaints filed by the respondents/workmen in the year 2015, full stop. By Annexure P-11 order dated 17/8/2018, the complaints before the Industrial Code with respect to the revision of salaries of the workmen by order dated 10/10/2015, cancelling the fixation of wages granted earlier by order dated 15/3/2010, which was alleged to be an unfair labor practice under the Maharashtra Recognition of Trade Union and Prevention of Unfair Labor Practices Act, 1971, within bracket hereinafter referred to as the Act, close bracket close, were allowed and the revision set aside, full stop. We have heard Miss Mayuri Raghuvanshi, learned counsel appearing for the appellant Maharashtra State Road Transport Corporation, within bracket hereinafter referred to as the MSRTC, close bracket close, and Mr. P. N. Misra, learned senior counsel appearing for the respondents, full stop. Both the learned counsel referred to a special leave petition within bracket civil number 19,507 of 2024, from which we refer to the facts and the history of litigation, the orders in which are also referred from the memorandum of the said case, full stop. Learned counsel for the appellant MSRTC would vehemently argue that the revision of the year 2015 was only in consonance with the order of this court in Maharashtra SRTC versus Premlal, full stop. The essential controversy was with respect to a settlement in the year 1956, which stood cancelled in the year 1978, both of which related to grant of time scale of pay and other benefits available to regular workers, full stop. The terms differed, insofar as the period in which 180 days continuous service as daily wage employee had to be reckoned, was without any stipulation of period as per the 1956 settlement, while as per the 1978 resolution it had to be attained within a financial year, full stop. Later, there was a settlement in the year 1985 which provided for absorption of daily wage working staff after completed service of 180 days, subject to conditions of a selection by the competent selection committee and only against available vacancies, full stop. These provisions were the subject matter of interpretation in Premlal, and it was categorically held by this court that they have to be read together, full stop. It is in that circumstance that the present revision was necessitated in the year 2015, as argued by MSRTC, full stop. It is also urged that, the very same conclusion was arrived at in a judgment of a learned single judge dated 6/3/2012, produced as Annexure P-5, which stood approved by the division bench by Annexure P-6 dated 21/8/2012, and the special leave petition filed, stood rejected as per Annexure P-7 dated 2/5/2000, full stop. Annexure P-7 categorically found that the judgment of the learned single judge was in consonance with Premlal, full stop. The exercise of 2015 was necessitated, since otherwise it would have created discrimination insofar as the time scale of pay granted to the daily wage workers, full stop. The dictum in Premlal was also followed by a learned single judge in Annexure P-10 judgment dated 23/6/2016 with respect to the grant of pay scale to daily wage workers on attaining the eligibility criteria of having worked for 180 days, subject to their satisfying all the conditions in the 1978 resolution and the 1985 settlement, full stop. The judgment of the learned single judge and that of the industrial court have to be set aside to bring parity with respect to similarly placed workers. Full stop. On the apprehension expressed by the respondents that recovery would be affected, the learned counsel for MSRTC asserts that the appellant does not intend to proceed for recovery, but the revisions have to be upheld and this would apply to the workers who are still continuing. Full stop. It is pointed out that even the persons appointed in the year 1992, who were respondents herein, would be regulated by the 1985 settlement. Full stop. Learned senior counsel for the respondent dash workmen submits that there are only few workers continuing in service who are affected by the revision and all others are retired long back. Full stop. It is pointed out that a refixation at this stage would seriously prejudice the retired workmen and also the serving employees who were granted fixation in the year 2010. Full stop. It is argued that the entire exercise has been carried out misconstruing the dictum in Prem Lal. Full stop. Prem Lal, in fact, held that the 1956 settlement, with respect to grant of time scales of pay applicable to regular workers to daily wages, was distinct and different from the regularization as brought out in the 1985 settlement. Full stop. None of the respondents who were complainants before the industrial court sought for regularization. Full stop. They only challenged the revision of pay scales granted in the year 2015, interfering with the earlier fixation of the year 2010, which revision in 2015 was without notice and without reference to Prem Lal. Full stop. Emphasizing that no absorption is sought, it is pointed out that industrial court in the complaints filed in the year 1992 and 1995 granted identical relief of time scale of pay to similarly situated daily wage employees, all of which have become final. Full stop.